Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I thought I'd do a video on something I saw online and bought myself a weapon to go with it. So, if you haven't seen this, you should go watch the full video first. I'll have a link in the description below. I'm going to show it sort of in small and only pieces of it that are relevant here. So watch the full video first. It'll give you a better perspective of what's going on. As a starting point, and this I've cut out because honestly we don't need to see that, the individual who is in the back of this particular video has been being highly aggressive and saying some things that are very ungentlemanly. To put it very sort of politely, he uses the N-word repeatedly in reference to the individual who's in the foreground, which, yeah, we'll see how that ends for him. But I'm going to discuss sort of how this would go in terms of if this file landed on the desk of a Crown prosecutor here in Canada. Of course, I believe that this happens somewhere in the States. I didn't actually check into where it took place. But if this were to happen here in Canada and this video was available to the Crown, what might they do with this and how might a court deal with it? So let's have a look here. I'm just switching over.
Oh God, you a clown! From here, you a clown!
So right away, we see him pick up the can, and the can is a bit of an interesting thing because it could be nothing. Like, this can is a beverage. It's not going to be held by the Crown or by a judge in this context to be a weapon. It's not inherently designed as a weapon, doesn't really have sort of weapon-like features other than, it's got some weight to it. But really it's intended as a beverage. That's its design purpose, and that's what I'm doing with it right now. It's all right. But we see him pick it up here in response to somebody who is behaving very aggressively and very insultingly. And the other thing I noticed just watching this little bit of the clip is his grip on it. He doesn't pick it up and hold it like this, but you can see, unlike this can, it appears that it's a tall boy style can. It's a larger can, and he sort of adopts sort of a fighting grip on it, if I can sort of describe it. He's got it held in his hand in a fashion that suggests that he might be willing to use it as a weapon. So if we assume, and again, the burden on the Crown here would be to prove beyond a reasonable doubt that that's a weapon. That's their burden. So he doesn't have to prove that it's not a weapon. The Crown would have to prove that it is. But they might be able to do that in this particular context just from the contextual cues. And further, if this individual was up on the stand, he might acknowledge that it's a weapon. He might say, yeah, that's why I picked up this can right now. I also don't know. We see him set some things down on the counter, and then he comes back with this can. It's not clear. I suspect that the can is in some sort of display, as opposed to one of the things that he had on the counter, but I don't know that for certain. And I don't know that much turns on it either way, but it is kind of interesting to think about how that can got there. Anyway, we see him sort of adopt this grip. The next question that would really come up is the question of, is this weapon now being, if this can, assuming it's a weapon, is it now being possessed for a purpose dangerous to the public peace? And maybe if he was carrying this can around with the sort of goal of, I could use this to hit people if something comes up, then that could be established. But here we see he only sort of grabs it and holds it in this fashion when he's confronted by somebody who is behaving, again, very aggressively, very insultingly, and who seems like he could transition to violence at any point. So at the point where you're faced with somebody who is sort of clearly an aggressor and clearly seems to have the potential to transition to violence, the court is probably unlikely to find that it's purpose dangerous to the public peace, even though this is a self-defense use. It's just he's availed himself of something here. So at this stage in the game, my conclusion would be that I don't think he has committed any offense at this stage. But let's move on and see sort of what transpires next.
Would you gonna smack me with that? Smack me!
So this is legally relevant here, where the guy is going, smack me, and, patting his face. This looks to me like consent. He is consenting to the application of force. And so at that point, when we start worrying about things like assault, assault involves, either the application of force or causing someone to have a reasonable apprehension that you're about to apply force to them without consent. And the reason why I say reasonable apprehension that you're about to is that you can commit an assault by swinging your fist at somebody and stopping short of their face. That's still an assault. You can commit an assault by pulling a knife and, making like you're going to stab somebody or that you might be about to stab somebody. So in this case, what we have here is a clear and pretty unequivocal and clearly communicated expression of consent. So he's saying, please hit me with the object. Let's see if that's what happens.
Smack me. Come on, get it. Drop him.
So we see him, he has been struck with the object, and he's actually quite lucky here, the guy who is the recipient of this particular can smacking, because just in terms of the physics of this, if that can had held together rather than bursting in the way it does, it would have hurt a lot more. If you've gone paintballing, the ones that you really remember for the next few days are the ones that don't break rather than the ones that do. Because, think of it like the crumple zones in your car where it sort of absorbs a lot of the energy. So that's probably why this guy is able to sort of bounce back and recover. But that's also important here because when we look at the case law, you can't consent to certain forms of sort of serious bodily injury, which don't appear to be the case here. I don't see any sort of scratches or, he's not had an eye gouged out or his face slashed up. So it's not something like, sometimes you see where people have been attacked with glass bottles and they suffer pretty serious wounds that you could not consent to. But he seems fine. He seems like he's okay. Now, let's say later down the road, he says, I have sustained some sort of serious injury that is beyond what I could consent to. The most obvious example would be something like he discovers later that he sustained a brain injury. The Crown, I think, would have some serious proof issues in terms of showing that a brain injury was not a pre-existing condition based on this particular individual's behavior. Just saying. All right, let's sort of see what goes on because there's more force applied here.
Yeah, you got yours, bud.
So right away, he comes back, and this is kind of important, and I really got to give props to the guy who's in the foreground here, because the guy who, just got smacked, he comes up and he puts up his hands, and he's, approaching. That indicates he has clearly continuing consent to fight, because had he stopped here and said, okay, I'm done. I don't want to, we're good. I don't want to fight anymore. And the other guy had continued to apply force, then it might be a situation where consent has been terminated and that force that happens after that could be an assault. But here, that consent is still ongoing. So far, I'm seeing consensual fight. And so far, I don't think that, this guy could be convicted of anything. So continuing on.
Throw me in I don't give a man. You learn this lesson, man.
Now, this is the point where things get legally a little more interesting. And of course, interesting means expensive, because this is the point where potentially they could lay charges. At this point, the guy is sort of on the ground. He's turtling up. And whether or not he's consenting to continued force after he ends up on the ground is open for debate. That's an open question. But it's not, there's not a whole lot of force here. And right now, I think it's kind of questionable as to whether there might be, let's say he says, I'm not consenting at this point to any further force. There might be a real argument as to whether or not it's clear at this stage that the fight is over, or whether, it's believed that this fight is still ongoing, because this guy who's sort of turtled up could be about to roll over. In a situation like this, you don't know if he's going to roll over and stick a knife in you or something like that. So this part is a little debatable, but Debatable is still good on the part of the guy who's in the foreground or starts out in the foreground, because quite frankly, I don't think that they'd necessarily be able to get a conviction here, but this might be enough that they might want to take it to a trial and for charges.
Call me another. Call me another.
Okay, 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 good, good, good,
Good?
good,
You good now?
you're good, you're good, you're good, you're good.
So at this point, we see some further force, and I think at this point, the fact that the guy on the ground here is not looking to continue the altercation has been made clear. And what we see is a little bit of, he's lifted up, he's held for a bit, and there's a process where he sort of confirms, we're good, this is not continuing, we're not going to keep having a fight. And then once that happens, and that's confirmed, he disengages. So I think he's still probably good here, although again, it's debatable as to whether or not he should have, picked him up and carried him and so forth. But I think this is still, again, I think this is a situation where they could lay charges and it wouldn't be sort of wildly improper, but I don't see this netting a conviction on the standards of proof beyond a reasonable doubt here. So the standards, at least where I am, for carrying a file on to trial is that there's a reasonable likelihood of conviction. Now here on the possession of weapon for purposes dangerous to the public peace, I don't see it. And in terms of the initial possibility of the assault with a weapon, to wit, beverage, I don't see that either, because it seems that there's clear consent there. The guy is not just saying that he's consenting and not just indicating that he's consenting, he's shouting it. It's hard to get, usually consensual fights aren't communicated quite as clearly as this one. So I think he's good on that. In terms of the next steps, when it actually turns into a physical altercation there, in my view, it's very likely that this would be found to be a consensual fight all the way through. And that I don't see that it's likely that there'd be a conviction here, but maybe. So this one is debatable. However, there's another part of the test here, which is public interest. And so the Crown has to evaluate, is there some public interest in proceeding on this? Now, assuming that the guy who, has the can of the twisted tea there, assuming that he doesn't have, sort of a lengthy record or any pattern of behavior, even if he does, honestly, on these facts, I think that a judge would be inclined to impose a fairly minimal sentence here. If he doesn't already have a record, I'd be thinking either an absolute discharge is well on the table on these facts, or a conditional discharge, which would be that he doesn't get a record, but they might put him on, sort of a term of probation first. So, we're not looking at somebody who's looking at a lengthy jail sentence or anything along those lines. There's no indication in the video portion that we have here that he was aggressing in any fashion. So ultimately, you've got somebody who's being sort of had this racist tirade and, aggression inflicted upon them, followed by sort of an invitation to violence. I don't really see the public interest in going after this guy. In my view, if I was the Crown and this landed on my desk, I'd be saying, let's yank this. This guy should not be going to a trial. And, I don't see a reason to prosecute this guy. But as I said, there's an argument that you could make. I don't see it. I don't see this guy getting convicted if he was in Canada. Now, I don't think we're done with our analysis because there's two people here. And so I think that the guy with the can of twisted tea is probably going to be fine here. Let's talk about the other guy, because he seems to be the bigger jerk in this particular scenario. And quite frankly, I think that a Crown prosecutor watching this video would be less concerned about the guy with the can of twisted tea and more concerned about the other guy. So what things could we go for that? Now, in terms of the assault, I don't think the assault is likely to be a possibility here because he doesn't take a swing here. He comes up and says, you know, hit me, and he gets hit. And then he comes up and puts up his hands and the fight continues. But he's got the same defense of consensual fight that applies to the other guy. It looks like they both kind of reached a point where they agreed to get into a fight. And that's fine. However, that doesn't end the issue here. There's a few things that he could be charged with. The first one is causing a disturbance, which says everyone who, not being in a dwelling house, and that looks like a convenience store to me rather than a dwelling house. So everyone who, not being in a dwelling house, that part seems to be met, causes a disturbance in or near a public place by fighting, screaming, shouting, swearing, singing, or using insulting or obscene language. And next is by being drunk or by impeding or molesting other persons. Frankly, he seems to tick all the boxes on this one. He's not in a dwelling house, he's causing a disturbance, and he is fighting, he's screaming, he's shouting, he's swearing. No singing. I didn't see any singing, so singing he gets a miss on, but we don't need all of them. We just need one of them. Or by using insulting or obscene language. He certainly seems to tick that box as well. By being drunk, I kind of think that's a big maybe. It might not be the strongest thing on this. We need some other evidence to say if he was drunk or just a giant jerk. Or by impeding or molesting other persons. He certainly seems to be doing that as well. So it appears that I think that they'd have a pretty good case on the causing a disturbance here. When we determine, was there actually a disturbance? Well, this turned into an actual fight. So I kind of feel like, yes, I feel like that one was made out. And so I don't think that one's going to be a big problem here. So I think that that's one that they could proceed with here. The other one, or another charge that they might want to consider, is this one, mischief, under section 430. Everyone commits mischief who willfully and obstructs, interrupts, or interferes with the lawful use, enjoyment, or operation of property. And obstructs, interrupts, or interferes with any person in the lawful use, enjoyment, or operation of property. Here, he's kind of preventing this business from carrying on business. This video actually ends with the individual with the twisted T leaving without his purchases, so they could say, hey, listen, you prevented these store owners from being able to carry out their business, and you prevented this guy from being able to do his shopping. So a mischief charge is possible here as against this one. So ultimately, it's... I think that, if the Crown was looking at this video and trying to decide, how are we going to proceed here, I think that they'd be much more inclined, in terms of taking a side, to take the side of the guy who, has the can of twisted tea, who doesn't appear to be the person who's he doesn't seem to want the fight. He kind of walks away, and again, watch the video for yourself. But he seems like he's just kind of upset and annoyed and frustrated by what took place. It's not like he went there looking for causing trouble or anything like that. He's just really kind of ticked off that that this happened. So anyway, that's kind of my take on it. I feel bad for the guy who has the can of twisted tea in that video because, again, it really looks like he's just exasperated to have to deal with that BS. And I'm sure it's not been great for him to suddenly be thrust into having sort of internet fame. Hopefully people are treating him well, but I know that with the internet, whenever you're sort of a public figure or, get recognition, there's going to be some people who are absolute jerks. So anyway, I guess that's sort of my analysis on this video. Thank you for watching. I hope you found this to be interesting and educational. If you have, please like the video. Please share it with your friends. Please subscribe to see more content. A lot of people asked me, hey, what do you think of this video as a lawyer? So I thought I'd better do a video covering it. So I also am going to include a link to, again, a better source for this video if you want to see it where it's not sort of cut down and interrupted with my my commentary, as well as my Patreon below. I want to thank my patrons at the $50 level: D-Mo, People of Canada, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, and Toronto Airsoft. At the $20 level, Cameron Johnson, Kevin Fleet, and Dale Nesbitt, as well as the $10 supporters in the crawl immediately following. Thank you for watching, and I hope I've armed you with knowledge. Knowledge usually works better than twisted tea, so thanks. Bye.